morning everybody. My name is Abhigya Ubri and I am from the Department of Faculty of Law and Governance, Jyoti Vidyapeeth University, Jaipur. So the topic that we will be covering today is the absolute and the strict liability under the law of torts. So let's first decipher what is the meaning of liability. A liability in any case arises where there is a duty and the duty is breached. So there are two very important things that are essential for the existence of a liability. That is, there has to be a duty and the duty has to be then breached. So now let's talk about the strict and the absolute liability. Like we can see from the name itself that strict liability is a concept which is a little strict in degree, but absolute is something that has no defense for. So we can say that it is almost the same thing. Both of them are liabilities. In both of them there is a breach and then there is a duty, but at the end the strict is a little lighter version of the absolute liability. So let's first deal with the strict liability. This concept was first, it's not an Indian concept, we've taken it from a foreign government. This concept was introduced in the case of versus Fletcher. So Raylan versus Fletcher is one of the most landmark cases of the law of torts. In this, it was held that there is a liability that a person has to take care of the property of the other person. For example, there were some essentials that were laid down in this case, that if those essentials are fulfilled, the person falls under the definition of strict liability. The first essential being that the person needs to have something dangerous on his or her property. So now what is dangerous? Like everybody keeps pets, but the pet can be a ferocious dog, a dog that is not supposed to be domesticated. So that becomes a dangerous thing. A ferocious dog becomes a dangerous thing. Or somebody for some reason has kept a python as a pet, or a lot of water. A water that is not used by a person in a normal day-to-day life, that's kept, so that becomes a dangerous thing. Second, the dangerous thing that a person has kept in the premises has to escape. If the dangerous thing does not escape, this liability does not arise. For example, if I have kept a ferocious dog, but the dog was in my premises, in my house, and the dog does not escape, so then I cannot say that I am liable under strict liability. The thing has to escape. The third and the most important essential for strict liability is that this escape has to cause a harm. If I have kept a fairly ferocious dog in my land and the dog just goes out, roams around, goes to the streets and comes back, I am not liable under strict liability. But if the dog bites somebody, injures somebody, I am liable under strict liability. So these are the three essentials that are important for a person to be liable here. But as we say that absolute liability is a liability in which there are no defenses. Strict liability is strict, but we still have some defenses to this. So the first defense is mistake of the plaintiff. That is, the person who is injured, or the plaintiff, or the person who has a complaint is at fault on his own. He is the one who made a mistake, was careless, was not cautious about something, and that is what resulted in this harm. So the first defense is this. The second defense is act of God. Act of God is generally a defense which is used where a natural occurring occurs, because we cannot absolutely control a natural phenomena. Also, we cannot foresee every possible situation that can arise from an act of God. So this is the second defense. And the third defense is act of a third party. In this, neither the plaintiff nor the defendant, none of them were careless, none of them were not cautious, but a third party came, did something due to which a harm was caused. So this is the third defense. Okay, so in this will cover absolute and strict liability.